Alright, this video is going to be about assault, battery, and intentional infliction of emotional harm. Those are three somewhat interrelated concepts. This video is going to be very long. I think there are going to be 10 cases here. So buckle up. But I think this will be a good one. So if you haven't seen the video on trespass, I'll go ahead and reestablish what we're talking about here. We're talking about torts, not criminal law. So a tort, I like to call it a civil crime. Essentially, a crime you committed against another person for which they're owed damages. There's a lot of different ways crime is maybe not the right word, but there's a lot of different words you can slot in there. An action you take against another person that results in you owing them damages, if crime seems a little bit intense of a word. And so these crimes or these actions are generally also criminal actions. And so trespassing, assault, murder, though it has a different name as a tort, that'll be pretty consistent. A lot of torts will have different names, a lot of torts will have the same names. It's just how it is. Assault and battery, for example, it's usually the same name both in criminal law and in tortuous law, which is always a fun word, tortuous. So, we're going to go ahead and run through these cases. I'm going to hopefully be reasonably quick. Where are they? Oh, there it is. Sorry about that. So, we're going to start with Vosburgh versus Putney. Now, Vosburgh versus Putney is a battery case, and we should quickly explain what are the differences between assault and battery. Punching someone is not assault. That's just not assault. That's battery. Battery is the contact, assault is the threat. Is a simple way to break it down, but I'll go ahead and give you the requirements for both assault and battery. So what battery requires is, one, that the batterer intended contact. Unintentional contact is not battery. Bumping into someone, not battery. If you're got your eyes closed and you're running around doing a punchy dance, woo, the end of the Breakfast Club punch going, and you accidentally hit someone, not battery. The batterer's actions caused the contact. So if I intended to make contact with you, but I didn't take any actual action to make that happen, for example, maybe one example that could count here is if your arm is hanging off the side of an escalator and you're going past another escalator and your hand smacks into somebody else's hand. You didn't care if your hand hit them, you kind of intended to maybe, but your action didn't actually cause that. That's not a court-based example. It's very hard for the first and second not to be met together. But sometimes there'll be cases where it's like you needed to intend to do it and actually do it. So this is just making it clear you have to have both intended and actually performed the action. You can't intend to perform battery. The contact must cause harm or offense. Patting someone on the back, patting someone on the back is generally not going to be considered battery, but if it causes harm, if your pat on the back breaks their spine because they have osteoporosis, yeah, that's battery. Causing the harm, even if it wouldn't happen to a normal person, still makes it battery. And the battery has to be non-consensual. If they consent to the contact, you reach your hand out to shake their hand, and they reach their hand out to shake yours, and you shake, and you break every bone in their body because you have a somewhat strong handshake and they have weak bones, on them. Now, if you take their hand and crush it, like, something you crush in your hand, like an egg, crush it like an egg, because you're big and strong, yeah, that would still be battery. They're consenting to a regular strength handshake, not to a gorilla grip, bone-destroying handshake. So that's battery. Now, when it comes to assault, sorry about that, I just realized I didn't have, there it is. So assault, there's three parts for assault. One, the actor intentionally causes another to believe that they will engage in offensive or harmful contact imminently. I am going to blow up the World Trade Center in 4 years. That's not assault. I'm going to murder you 4 years from now. Not assault. Especially if it's clear that I'm saying in 4 years exactly. It's not assault. If I repeat the threat, 3 years and 11 months, 3 weeks, and 6 days from now, yeah, that's probably assault. But imminence is an important part of assault. Then your affirmative conduct must communicate the same, right? So if you're joking, that's not assault. You can't. Joking is a defense to assault. But say, I'm going to take my sword and stab you, but I don't have a sword. It's not a real threat because I have no sword. I have to have a bit of capacity to act on that and show a bit of step towards acting on that for the assault to be real. And then the other person must not consent. That's very important. You can consent to be threatened. Okay? If someone says, hey, assault me, and you make a threat to murder them and pull out your gun, they've consented. So both assault and battery can be consented to. There are conditions where you cannot consent or conditions under which your consent is not correct. Your consent must be properly done. So now we're actually going to get to the case law now that we've distinguished the two torts. So our first case is Vosberg versus Putney. An 11-year-old child kicks a 14-year-old and exacerbates an underlying injury. The underlying injury was he had some damage to his leg. After this kick, that got exceptionally worse. And this kick was not hard. It was a light-ish tap. How light, how strong, not clear. But it did not leave a mark outside. Inside, it damaged the bone. And the defendant was ultimately held liable for all the damages resulting from this kick. As is the rule of torts, his lack of foresight to the degree of damages was completely immaterial. Right? Also, his age was immaterial. He personally wouldn't be held liable. He wouldn't be the one to pay. His parents would. But just because he didn't know that light tap could cause damage, that doesn't matter. I've heard this called the eggshell doctrine, where it doesn't matter if you're the person being injured, his bones are made of eggshells, and his heart is the size of a pea. And so when you give him a, light tap on the shoulder as a nice, good job, buddy, and you completely shatter every bone in his body, if you did assault him, you're liable for the full damages done to him, not just the foreseeable damages. Your ability to foresee damages your inability does not protect you from that. And intention is necessary for the tort of battery, but degree is not, right? So the tap is intentional, the tapper is at fault. But if he had consented, if the other kid was, if tapping was how these two kids communicated, in the middle of class, instead of passing notes, they tap each other on the foot, that would be a defense. All right, no. Apologies for the cut, accidentally stopped my camera. So for the next case, we're going to do Mohave v. Williams. Now, Mohave v. Williams is about a doctor. They examine a patient's ear, the right ear. They find that it is diseased and needs surgery. They find that the left ear is diseased but does not need surgery. During the surgery, these facts are swapped. They find that the right ear can almost certainly be treated with medicine, and the left ear definitely needs surgery. They go ahead and perform the surgery, assuming that the patient's consent for their surgery for the right ear meant they could do the left ear. The court ruled flatly that no, the contact was unauthorized. There was no permission to perform the actions that they did, and so they committed assault. My apologies, they committed battery. No assault here, just battery. Now, there are a few defenses that could have worked but wouldn't have worked in this case. Implied consent is more and more of a thing, but that focuses nowadays more and more on surgeries that are more invasive and more risky. So, for example, if there's a case of a woman who they were doing surgery on some of her internal organs. They see there are these cysts on her ovaries, and they pop them. It's just something that they would have had to do, and so instead of going and doing another surgery, they just go ahead and do it. The resulting damages from the popping of those cysts is not the fault of the doctor, as it was a reasonable medical action to take. But again, they don't have that defense here. There's also emergency doctrine, where unconscious patients can be treated to the best capabilities of the doctor until such a time as they are conscious or someone can stand in for them to give their consent. Now, that didn't apply here because this wasn't an emergency. They could have waited, and their choice not to wait is what put them at fault. All right, so for the next interesting case about assault we'll be talking about here is Hudson Craft. Now, a boxing promoter ends up holding an illegal fight, and someone gets injured in it. The man who agreed to be in this fight, whether or not he knew it was illegal, immaterial. But he did probably know that the fight was not legally held. And so he sues the boxer for damages that he incurred during the fight. And it is made clear by the court that yes, he is 100% liable because his actions were what encouraged the assault. Now, yes, or the battery. Yes, you can consent to contact. You can even consent to be battered. But because he was not following the regulations of the state, the promoter, he was in violation. And people have a right to be protected from their own stupid actions. And so the stupid actions of this man consenting to a dangerous fight were not really consent because he was protected against making that consent. So the fight was illegal, and so the actions during the fight are ultimately illegal and liable towards the promoter. Why were they not liable towards the guy who actually assaulted him? Because it was the action of the promoter that created the conditions under which this illicit assault occurred. So you can't consent to do something illegal nor have something illegal happen to you. And so he's consenting to be in a fight, but he's not consenting to be in an illegal fight because you can't consent to being in an illegal fight. So hopefully that makes sense. It's a little complicated, but ultimately it just boils down to you can't consent to have something illegal happen to you. And since it was a prize fight, and since they were getting paid and people were paying to see it, he can't consent to the fight itself. Had they been on the street and said, let's beat each other up, that probably would have passed the smell test, and he would not have been allowed to make this case against the person he was fighting. But again, he made it against the promoter of the fight, the man who encouraged him to get in the fight. All right, now next we're going to go over McGuire versus Almy. This one's really simple. A mentally impaired person hits their nurse with a table leg. Are they liable? The court states pretty clearly, when an insane person, by his act, does intentional damage to the person or property of another, he is liable for that damage in the same circumstances in which a normal person would be liable. There is no insanity defense to torts, generally. Welcome to law, there's always an exception, but generally speaking, there's no insanity defense to torts. Insanity is a criminal defense. Torts are criminal, they're not crimes, if that makes sense. All right? Now, Courvoisier versus Raymond. This next section we'll be doing, I believe the next two, is going to be self-defense. Courvoisier v. Raymond and Bird versus Holbrook. Now, Courvoisier versus Raymond. A jewelry store owner shot a cop who was arresting some thieves. Now, to be clear, the conditions of this arrest are pretty complicated. The court finds it as a riot, is the term they use. And it should apply. I'm looking at the facts of the case. There's a lot of people involved in trying to break into this man's store. Maybe a dozen or so. And so when the cop shows up, it's not fully clear that the dangerous situation is over, or even to the man who, Raymond, the man who shoots Officer Courvoisier, it's not clear to him that that actually is a police officer. And so when he sees him reaching into his jacket, pulling something out, he shoots at him. So the jury was given instructions directing them to fine for the plaintiff if it was found that he was not assaulting the defendant. The appeals court states that it did not take into account the idea that the shooting may have been justified for other reasons. Now, this is not them ruling that the shooting of the police officer was justified. It's ruling that assault is not the only predicate justification for assault, and you cannot instruct a jury that that is true. So there are other defenses for assault, other self-defense bases, justifications for assault, including the belief that you are going to be assaulted. Self-defense can happen even if mistaken. A child with a... so we'll go ahead and the Timur Rice case in this instance, right? If you've heard about this, the kid had a gun, he took the airsoft gun, takes the orange tip off of it. The police officers shoot him. It's a police officer, so they have certain other duties and obligations that may have made it criminal, may have made it just impermissible what they did. But if a normal person saw that kid and shot him because he's waving a gun around, they're completely within their rights in terms of self-defense, because a kid with a gun is just as dangerous as an adult with a gun. that doesn't make any difference. And the fact that he's pointing a gun at people, or at least you assume, right? That's why those orange safety tips are there. The same case may turn out a little different if the orange tip is still there. But that is to say, if you're mistaken, and in fact it is a BB gun, which it was in the Tamir Rice case, you're still within your self-defense rights to do that because you don't know that it's not a real gun. You don't know that it's an unloaded gun. You don't know that the knife's not sharpened, and you don't know that the grenade has no powder in it. So if somebody is brandishing a fake weapon, there is no difference under the law than that in a real weapon, assuming it's not a weapon that can be distinguished from a real weapon. A kid with a Nerf revolver, you can't shoot him. You know that's a Nerf gun, or you should know that's a Nerf gun. A reasonable person. A lot of these standards are up to reasonability and a reasonable person. If you see somebody with a Nerf gun, you should reasonably be able to tell that it's not a real gun. All right. So the other self-defense case, there's a couple different interesting landmark self-defense cases in terms of traps. Bird versus Holbrook is the case this book went with. Catco is the one I'm slightly more familiar with, and the book does touch on this. But Bird versus Holbrook, a man sets a trap in his garden, specifically a spring gun, to go off when anybody trespasses in his garden. Now the boy goes over the wall to get a lost bird, and the gun ends up shooting him in the leg. The gun was there not to deter; it was there to injure, and that's the problem with it. You can't actually have booby traps, but they must have the purpose of deterrent. Now, how do you have the purpose of deterrent? You need to tell people it's there. If you tell people, a trespassers will be shot sign would likely have saved this man a lot of trouble. So there are specific conditions listed for what you can do with a trap, right? So the use of a device is reasonably necessary to protect against intrusion. If you have better options, or way better options, or reasonability just isn't there, again, stuff like that. Better options does not mean, this is probably better. No, you really do need a certainly better, and an option so much better that the option of using a trap is not reasonable. Remember, reasonable minds can differ. That's a very important phrase to understand in the law. So the use of this specific device is reasonable. If for whatever reason the device specifically used is not reasonable, I don't imagine there are a lot of cases, but a lot of times you'll see there are 3 to 5 points about where it makes it so you can or can't do something, and one of them sounds like a restatement of the other point. You will run across a few cases on occasion, but the use of this specific device is reasonable. The device is commonly used or notice is posted. So if it is standard throughout the great state of Minnesota for bear traps to be on everyone's front porch, even if they're hidden, that's what's there. That's what everybody knows about, or you should know about, or everybody does that. Then you don't need to post notice. Otherwise, you need to post notice. I can't think of a single case on place on planet Earth where a booby trap is normal, and so notice would generally be necessary. But sometimes these restatements, this is where this is from, the restatements of law, will include non-existent defenses or conditions, ones that could never be met, just because if they were somehow met, that would still be a defense. And then it is not intended nor likely to cause serious harm. So essentially spring guns would always be out, as they are intended to generally and likely to cause serious harm. If it's going to cause serious harm, it's probably not an okay booby trap. But pieing someone in the face, probably okay. All right. So on to our next section. So this is talking about assault. So this is IDS and wife versus WDS. So semi-anonymous case here. A man swings a hatchet at a woman and misses. This is still assault, right? Assault, again, different than battery, is the threat. Him swinging the hatchet, he says, I didn't mean to hit her, that's why I missed. Doesn't matter. If I shoot over someone's head, it doesn't matter that I'm the best shot in town and I knew where I was shooting. They didn't know that. And so once you start committing something that could be assault, a lot of what's going to matter is what's in the head of the other person. When they start to feel fear, you've probably committed assault. Real quick, the assault, again, intentionally causing another to believe that you will engage in offensive or harmful contact, Your affirmative conduct does the same, i.e. communicates that same thing to the other person, and third, the other person doesn't consent. For a lot of torts, you can consent to them. Most of the time, you can consent to being assaulted. Tuberville v. Savage is another interesting case about conditional threats. If the judge were not in town, I'd hit you really hard. That is essentially how I boiled down the quote, and that's how the judge boils it down too. Yeah, that's a conditional threat. The judge is in town. It's not a real threat. He's not going to do it. It doesn't matter that he's putting his hand on his sword. He's made it clear. He just said, if now were now, I'm not going to assault you. If truth is true, I'm not going to assault you, because it was true. The judge was in town. And this kind of translates over to, if I weren't such a good guy, I'd beat you over the head. You can say that. That's not a threat, because you're not going to beat them. You've just said it. You're such a good guy, so you're not going to beat them. So again, the threat would not be carried out, so there is no intent. When a threat is real, or may be real in the mind of the assaulted, matters more than what's in the mind of the assaulter. But language does matter too, right? So the other person might have thought they were going to get hit, but he made it clear he wasn't going to hit him. And that does matter. Now, back to battery just really quick. Spitting on someone is battery. Alcorn versus Mitchell. Offensive conduct, it's not just harmful, also offensive. Peeing on someone, spitting it. Don't put your bodily fluids on anybody. That's something we learned in kindergarten. It is a crime. So if you spit on someone, that's battery. Especially if done maliciously. If a conduct is done with pure malice and no other reason, there's often ways to make it. There's often ways that it will slot into one crime or another. Doing things with malice is generally not what you want to do. The law does not smile on that set of actions. Now, the next case we'll be doing real quick is Coblin versus Kennedy Incorporated. Now, this is a false imprisonment case. I'm going to just tack these last two quick ones on the end, just because I don't feel like making separate videos. But Coblin versus Kennedy Incorporated. An old man is stopped outside of a store on suspicion of theft. The employee grabs his shoulder and asks him to come with him. Now, the employee's problem here ultimately ends up being that he had no real grounds for suspicion of theft. Just with the facts of the case, the man was wearing an ascot when he came in, took off the ascot, put it in his pocket, put it back on. When he's leaving, the employee comes out and is like, "Where did you get that ascot?" And he makes him come back inside. That is false imprisonment. Normally, there would be nominal damages here to represent that a wrong had been done. However, in the course of coming with the employee, the old man has a myocardiac event. Not a heart attack, but something similar. And, well, you were falsely imprisoning him at the time. You are liable for that damage caused. That's one thing that has to be understood. A lot of the time when you're establishing nominal damages, it's being said, hey, you didn't really do any real quantifiable damage. But if you had, even unintentionally, it could have been a lot of money, right? And so that's the case here. This could have been a lawsuit regardless of the old man getting hurt, and he could have earned his nominal $1, or, $20 if it was 15 minutes of his time, whatever it is. Whereas because he was injured during that time, he does receive a large sum of money. And then we're going to talk about outrageous conduct causing emotional distress. So this is sometimes called emotional assault, emotional battery, a lot of different terms, but the term provided here is outrageous conduct causing emotional distress. One whose extreme and outrageous conduct causes distress of the emotional or physical kind is liable for damage. So if your distress, if you make someone feel such distress intentionally that they have a heart attack, that is your heart attack to pay for ultimately, and that's essentially what happens in the case of Wilkerson versus Downton, not downtown, Downton, like the Abbey. A woman goes up to her friend and goes, "Your husband broke both of his legs, you need to go see him immediately." The woman goes into nervous shock and has some long-term health issues because shock is not good for the body. As a result, she is held liable to pay for those injuries. Then there is a second form of emotional outrageous conduct causing emotional distress, whereas if a conduct is directed at a third person, the actor of the conduct may be liable for emotional or physical harm to a family member if it was caused by their actions, even though it was directed not at them. or physical harm to any other person. So the emotional distress can be paid out to the person directed at or their family, but if it's someone present, only physical damage can be assessed. And so in the Wilkerson versus Dalton case, she was, of course, held liable as she caused damage to the woman she directly causes emotional distress to. All right, that's probably going to be the longest video for a while. Hope you all have a good night. Again, if you have any questions about any of these cases, please do leave them in the comments. I went through these pretty quick, and it's always helpful to get questions about them. The more I talk about them, the better I'll do on the exam. So hope everybody's having a good one, and hope to get some questions in the comments. Thank you all very much.